Case number 113746, State of Kansas v. Riffey.
May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Mr. Riffey. May I please have 3 minutes for rebuttal?
3 minutes is granted.
Would you still care for a recitation of the facts?
Because we're live streaming, people at home want to hear you tell us what the facts are.
Well, I will highly condense the facts in this case because the underlying trial facts are relevant, even though we're specifically here on a sentencing issue. This case arose after a night of drinking between, of all parties involved, at a Halloween party in Hutchinson, beginning at one bar and then following to another bar that was attached to a Ramada Inn in Hutchinson. Later in the evening that night, the victim in the case, C.H., left with Mr. Riffey in his pickup truck to go to her house. C.H. gave Mr. Riffey directions as he left, and as they're driving off, she begins disrobing, taking off her fishnet hose and stiletto heels. A few blocks away, Mr. Riffey had to urinate, and so he turned off onto a street next to, I believe, a hospice house. And the events that followed, what happened next, as they say, was the subject of dispute. Mr. Riffey said that she had been making advances towards him throughout the entire evening. Other witnesses said similar things. Eventually, in the parking lot, and on the ride over, she had been making advances, reaching over, trying to kiss him, etc. After he finished urinating in the parking lot, went over, opened the door, she about fell out. He realized she was extremely intoxicated, set her back on the bed of the pickup truck, tried to get her dressed, as if by this time she was only wearing her bra. When he said he was going to take her home, she apparently, quote, freaked out and ran off. Miss C.H., on the other hand, said that Mr. Riffey attacked and attempted to rape her in that parking lot. She got away by kicking him. But regardless, it was undisputed she ended up at a nearby Days Inn wearing only her bra shortly thereafter. The state charged Mr. Riffey with aggravated kidnapping, attempted rape, and aggravated sexual battery. The jury obviously didn't buy the entire state's theory, only convicting Mr. Riffey of aggravated sexual battery. And so at sentencing, they imposed a 47-month sentence and 24 months post-release. Again, like some of those other cases that we've heard today, DOC contacted the state saying he should have had lifetime post-release. State files a motion to correct a legal sentence, and the defense challenged this under the Freeman factors in the Eighth Amendment. And so here we are today after the district court agreed with the defense and imposed, not sure quite exactly where the number came from, but 10 years of post-release, saying that was the just result after reviewing the facts and circumstances of the case. So, with that background in mind, moving to the first issue, which is unrelated completely to the merits, does Godfrey apply to the state? In this case, I raised this issue in my brief. State didn't file a reply brief. The Court of Appeals skirted the issue, first trying to say it couldn't understand what issue I was talking about that they didn't raise. And that really didn't make any sense to me whatsoever, because I said the state's sole issue on appeal, they failed to comply with Rule 602A5, and there was only one issue on appeal, so I'm not sure how we get confused on what issue I was talking about. There was only one issue raised by the state. Then the Court of Appeals tried to say that Godfrey only applies to constitutional issues raised for the first time on appeal. And I believe in my supplemental brief, my 609 letter, I point out that's not the case. Even the Court of Appeals has been applying it to civil litigants. Godfrey, quite simply, either applies to everybody or shouldn't apply to anyone at all. And it's, to date, counsel is unaware of any time this rule has been applied to the state, and this case provides the opportunity for this court to do so. So with that in mind, the court should not even look to the district court's lower court's decisions below because the state failed to comply with Rule 602A5. If we look to even prejudice on this issue, we acknowledge that the state did object to this district court's decision below. But the problem in this case really arises because the facts as set forth by the district court were not crystal clear exactly how they applied. And the state tried to argue that they weren't supported by substantial competent evidence because they conflicted somehow with the sentencing statements at sentencing. Well, the state had an opportunity to ask for clarification of those written findings by the court. They didn't do that. As a matter of fact, they filed their notice of appeal 22 days before the deadline to file their notice of appeal. There was plenty of time to ask for clarification. And they didn't do so. And we're hindered by that because the state's argument is that there's a difference. But at the same time, there are other reasons why the district court could have reconciled its statements. And I mentioned those in my brief. One of the big ones was the victim was present at the sentencing hearing, and the district court wanted to recognize that the victim had specifically requested a prison sentence. That's a good reason why, whereas this was a one-time, the district court could have felt that while this was a one-time instance, at the same time the wishes of the victim played into the reason why it would impose a prison term.
Can we get down to what occurred first at the district court?
Sure.
And one of the basic things that happened, well, first the state argued in its brief that the district court erred when it decided it would not consider the last two factors of the Freeman factors in its analysis. I mean, clearly that was briefed, that was argued at the Court of Appeals. That's properly before the court. And I think issue one also is too. But here we have the trial court that simply didn't consider two of the three factors that it's mandated to consider when applying the Freeman factors in its constitutionality as applied analysis. Why doesn't that just render this not complete? There's just nothing about that in either the district court's ruling from the bench or in its findings of fact.
I'm sorry.
Go ahead.
Not trying to interrupt. Yeah. In all candor, it was my recollection the district court said that they didn't apply.
They don't apply. Why?
Not that it didn't consider them, just that they didn't apply.
They didn't apply because it wasn't a child sex case. I think is what he said.
Yes.
Didn't fit into that category. Isn't that just wrong?
As a matter of law?
Just
I
wrong.
think we've got legal error that
I think
goes
it probably
back for-
might be.
Okay, so that's a do-over,
The
right?
problem,
Yeah,
again,
let's just get. Isn't that just flat out wrong?
I think it probably is wrong, in all candor to the court.
Okay.
But again, this is another problem with the state failing to comply with the rules of the court.
No.
The state didn't really brief that.
Well, the state raised it in its brief.
It was
Argued it.
tangentially raised really.
And then the Court of Appeals addressed it by saying basically that was a finding in favor of the state, and I don't think you didn't.
No, I don't think that's the case.
And you didn't appeal that.
No.
In your petition for review, all you did was copy and paste your Court of Appeals argument as it relates to that in your petition for review.
On that, yeah, frankly, I wasn't here to argue about, that wasn't something we necessarily had a bone to pick, because frankly, I think this case rises and falls on the first factor. If we reach the Freeman analysis, that was my opinion. And that's why I didn't raise that in my petition for review. However, yes, I'll candidly admit to the court that that's the case, but I will also say that the state had a duty to raise these things, and I did cite to the fact that absent any objections by the parties, this court has to presume that those findings were correct with respect to the second and third findings. And that was discussed by the court, although, again, to my detriment, They disagreed with the conclusion that I had that they should come out in my favor. But again, I was focusing on the first factor, which I think the Court of Appeals completely got wrong because it engaged in a reweighing of the facts.
Yeah. Well, let's talk about the first factor also, is that the factors that the facts that the district court cited to, apparently the age of your client, his employment, in fact he's married, he has kids, those kinds of things weren't ever really argued at either the hearing or it seems to me that then when the state asked for the court to produce findings of fact, these are the things he pulled out from the weighing of the aggravated and mitigated factors when he was doing sentencing. Those weren't really argued as to how that would affect the first factor. I mean, no one presented those facts.
I thought, the record will bear it out, but I thought those were actually in the motion to find it unconstitutional. They weren't orally argued at the district court hearing. I'll agree with you there.
Yeah.
But they were in the motion. And likewise, the factors were that the Court of Appeals said were not supported by substantial competent evidence, specifically that post-release, part of the purpose is avoiding recidivism, and that he had no problems in prison or on post-release. Those were raised in defense counsel's motions. And we know that in sentencing, we're not bound by strict application of the rules of evidence, and arguments of counsel can't be considered by the court. So in light of that, and I think the Court of Appeals was off by not acknowledging that that's the rule with respect to sentencing type situations. So I think those factors also should have been rolled into the first factor of consideration also. Does that answer your question? So I think also, so with respect to, just briefly to finish up on talking about substantial competent evidence, the Court of Appeals kind of seemed to rely on perceived inconsistency between the resentencing hearing and those of the original sentencing hearing. And it's our position that that's really, again, the state's fault. They should have brought this up sooner. And the fact that we're dealing with an apples and oranges type situation. It's really not the same thing. In that situation, the district court was saying prisons, what I think is appropriate. And in that situation, you had A, the victim saying, I want prison, and B, you have what the district court was under the impression was a 24-month post-release period. Here, at the resentencing, the district court now is reconsidering how things, how public safety and such is affected in light of the fact that it's now giving this 10-year situation, or in light of the possibility of lifetime. And that's a very different consideration on how the defendant dealing with society and whatnot, and considering the fact that he'll be registered outside that 2-year time. It's just different.
It's different, but isn't that just speculation on your part that if the court had known the post-release supervision period was different, that he wouldn't have imposed the aggravated sentence? You don't know that.
Actually, I think you've just made my point.
Well, no,
that
I don't
the state
think so.
should have brought this up so we could know exactly what the district court thought. By the Court of Appeals guessing in and of itself, while the district court really felt he was dangerous, that's exactly what you just did right there. And that's not what the role of an appellate court is. We are not in a position here to argue about facts and what was in the fact finder's mind. And the district court is the fact finder. So, running short on time, I wanted to touch briefly, first of all, on the very last issue in my supplemental brief, and then back to the actual number, what the state called an illegal sentence. Something that's been happening, I've noticed in the Court of Appeals, is the Court of Appeals dictating what a specific sentence should be on remand. And I point out in my supplemental brief, that's not the appropriate role of the appellate court. Appellate courts aren't sentencing courts. If this court finds that, yes, there were some problems with what happened at the resentencing hearing below, the appropriate remedy is to go back and remand for resentencing, which allows for a consideration of everything else. Just like in a departure case, when the articulated factors are not clear, when appropriate, the court goes back and has an opportunity to properly articulate things. This is exactly the same. We have facts that the state is arguing weren't clearly articulated. And if there's a problem with what the district court actually meant when it was saying something, this court should be sending it back so the district court can properly articulate that. Because again, the district court is the factual finder here, not the appellate courts.
Did the court have the authority, once it found it unconstitutional, just to set post-release at whatever?
Well, that was the third issue that I'm glad you mentioned that, because that gives me an excuse to keep talking a little bit. I initially said no. I think the court is bound by 24, somewhere a range between 24 to 60 months. Now, up until, and I'm kind of stuck a little bit because I didn't 609 this case, but there was a case this court recently argued that it was always my impression that the district court is bound by statute and strictly controlled by statutes at sentencing. And there was a recent case where the court said, well, that's not always completely hard and fast. And there was some dissent in that case. But if we are strictly controlled only by statute, then yes, it would seem to me that we are in a position where it has to be 24 to 60 months, and 60 months being a situation where there has to be a departure. If, on the other hand, when it's something that's not spoken to, the statutes don't speak to, then I think that the court could go outside that. And there is no statute speaking to what happens when a court finds something cruel and unusual. And so if that's the case, then it would seem that it would be appropriate for the district court to be able to fashion its own remedy.
Well,
Something less than the full...
I think you're referring to the Quested case.
I wasn't going to say that.
And that reliance was on common law. So
Sure.
what's your common law authority to impose a 10-year post-release in this case?
I have absolute candor. I had a real problem finding any case where they said what the remedy was. I looked and I found occasionally a case saying something was disproportionate, but I could not find anything saying what the remedy was. And I looked outside Kansas on this. So I just don't know exactly. It just seems, and I made basically a policy-based argument in my supplemental brief that it seems like it might not be the best policy to say, well, you get no sentence at all. Like perhaps I gave the example of a shoplifting case where the district court made what would clearly be a cruel and unusual life sentence for a theft, and then, so would there be no punishment at all? And that would seem to be the result if
the analog is, say, departure sentences. We have case law that says if the statute authorizing an upward durational departure is unconstitutional, it's null and void, and there's no mechanism by which any departure could be imposed. Under that analysis, then post-release would not have statutory authority of any duration.
Sure, and I'll concede Mr. Riffey would be more than happy not to have 10 years of post-release. I'm just trying, in a duty of candor, that's, I believe, a facial unconstitutional situation as opposed to an as-applied situation, which is what we're in when we talk in terms of a proportionality challenge. It's in a categorical challenge, we certainly, and that's how you get the result in another case. I can pretend we don't know what it was, a juvenile post-release situations where the court said, no, we have to have, of course, nothing, but that's a difference in that was a facial constitutional challenge as opposed to an as-applied. And I, again, apologize for not 609ing these things, but...
We have any more questions? Thank you, counsel.
Thank you.
May it please the court, state appears by Assistant District Attorney Daniel Gilligan of Reno County. Mr. Riffey is challenging the fact that, or the state's challenging the fact that Mr. Riffey was given 10 years, and the state's position is that is an illegal sentence. The application of the Freeman factors in the district court the appellate court found that a sufficient factual basis was made by relying on State v. Gaither, 28 Can 61 or 671, indicating that if neither party objects to the factual basis, then the appellate court can presume that a factual basis was present for the conclusions. And in that case, a factual basis then was made for the second and third Freeman factors.
But there were no conclusions by the district court on those factors, were they? The district court said they don't apply and just didn't deal with them, right?
My understanding was that they said that they ruled in the state's favor, and in fact, the Court of
That's what
Appeals.
the Court of Appeals found.
That's what the Court of
Right.
Appeals said. But that's not the Court of Appeals' role, is it? It's supposed to be the district court in the first instance that finds facts and draws conclusions of law.
Right.
So there really wasn't anything for the Court of Appeals to review, period, on second and third factors.
Right.
And do you agree with my colleague and me that it's required for the district court to examine all three factors? That the district court made a legal error when it said that the second and third did not apply because it wasn't a child sex case?
Yes.
Okay, thanks.
Counsel, well, since we're talking about the Freeman factors, I'll just ask my big picture question.
Okay.
Do the Freeman factors have any underpinning in either the history or the text of the Kansas Constitution?
I think that the Freeman factors have been applied by the courts.
Certainly it's the law of the state with regard to Section 9 right now. My question is, does it have any underpinning in the history or text of the Constitution?
I'm sorry, I'm not aware. With regard to the Freeman factors, the state's main position is that if you look at the disproportionality of the punishment to other jurisdictions, this court has repeatedly found that that is not the case in Coleman, in Mossman, and even in the state of Kansas v. Dunn, when it noted that 18 other states had imposed mandatory lifetime post-release supervision for at least some convicted sex offenders, and found that the second Freeman factor was not in favor of defendants, and that the lifetime post-release was constitutional. And the third Freeman factor, the case law has also found in the same cases that the fact that the punishment of lifetime post-release is not disproportionate to any other crime more serious in the state of Kansas, and even if an underlying an underlying term of probation for a homicide would be shorter, the fact that the underlying punishment is higher indicates that the punishment is not disproportionate. So the second and third Freeman factors do in fact still weigh in favor of constitutionality and the fact that it's not cruel and unusual punishment.
You didn't brief that though to us, did you? Just what you recited?
No.
No.
I didn't.
I mean, basically what you're reciting to us is what the Court of Appeals did.
And
you didn't brief that to the Court of Appeals or to this court. And I guess my question is what do we do if we find that the district court erred by not considering the factors 2 and 3? What should we do?
And I think that is a procedural error that the district court did not address. As we heard in the first case that I argued, when the district court makes an error, remanding it to the district court to fix its error is probably the best idea.
Is that what you're asking us to do?
Well, because the appellate court was able to adopt the findings as the factors, saying that because they're legal conclusions and the legal conclusions previously reached in the state indicate that the second and third factors are almost a non-issue because of prior case law, I think that we can turn on the facts that the court did offer for its finding under the first Freeman factor, that his punishment of lifetime post-release was cruel and unusual, can be examined. And that is what I'm prepared to argue today, that the factors, when the district court relied on Proctor to say that a departure from lifetime post-release was proper because it was cruel and unusual, that the district court erred in relying on Proctor. The facts are completely dissimilar to Proctor, when you look at the fact that Proctor was 19, younger than that when the crimes were committed, had no priors. Mr. Riffey was 39, had priors, prior person felonies. When you look at Mr. Proctor being given probation, Mr. Riffey being given the aggravated number at his sentencing and having his sentence imposed, the fact that Mr. Proctor was apparently the subject of sex crimes himself, Mr. Riffey was not. All of the factors that the court relied on, apparently, using Proctor, are not present with Mr. Riffey. So for the court to rely on Proctor as guidance that Mr. Riffey's lifetime post-release was cruel and unusual punishment is...
How is what you just did not reweighing what the district court apparently did?
Well, because it's a de novo review of the conclusions of law. You've got this. These are my facts, and you review those facts and draw legal conclusions from them. And when the facts are completely contrary to the legal conclusions of the Court of Appeals, then your de novo review of the conclusions of law have to indicate that the court can't make those findings based on those facts. So, based on the fact that the first treatment factor weighs in favor of the state in comparison with what the district court relied on in Proctor, based on the fact that the second and third treatment factors have already been found to be not cruel and unusual in the state of Kansas based on the prior case law already cited. The other argument that's been made is that this is a argument that's been brought up for the first time on appeal. This is not a constitutional argument that's been raised for the first time on appeal. This is a constitutional argument that was raised by Mr. Riffey at the district court. The state responded at the district court, and so now we are appealing from a constitutional issue that was raised first by Mr. Riffey in the district court. So the state's position is that we are properly before the court and that there is no error in this court having jurisdiction to hear this appeal. This is a operation of statute. As this court has already heard, when the law changed in KSA 223717 D1G, many of the state's district courts were caught off guard when they got the phone call from the DOC saying you did it wrong a couple of years later. And as a result, several sentences have come back as illegal sentences because they did not comport with the statute at the time. This court has taken that statute and said lifetime post-release can't apply to juveniles. The legislature reacted, and it does not apply to juveniles now, but it left alone the fact that when you have a sexually violent crime, which is the case here, then lifetime post-release is appropriate. The facts of the case, I suspect that CH would disagree somewhat with the recitation as provided by counsel. CH's position was that she was in need of a ride home. She had spoken with Mr. Riffey earlier in the evening. He offered to give her a ride home. When he failed to follow the directions on her ride home, she got worried. Then he grabbed her hair, and she did have bruising on her head and on her abdomen. She had to run naked for, and again, I'm not sure that this is in the appellate record, but she had to run naked for quite a ways to get across a field on 23rd Street to 23rd Street, where the hospice was located, to off of 17th Street, if that can give you a frame of reference, run across an open field to get to the Comfort Inn, where she was eventually able to wear a garbage bag because she was admitted into that facility with only a bra on. This is the kind of crime that lifetime post-release was meant for. It was a violent crime. Based on those underlying facts of the case, the fact that the district court felt he was a danger, gave him the aggravated number, sentenced him to prison, the state's position is that lifetime post-release was appropriate. It was not cruel and unusual. Are there any questions?
I see none. Thank you, counsel.
I guess since the state's talked about Proctor, I feel like I should probably discuss that a bit myself. Yes, the defendant in Proctor was 19, Mr. Riffey was 39, but Mr. Proctor was pled guilty to aggravated indecent solicitation of a 12-year-old boy in lewd and lascivious conduct. There was actual sexual organ contact, and unlike this case, in Proctor, there were multiple occurrences of sexual touching of a child. That's pretty egregious factual-wise when you compare with this case, which, admittedly, if the state's recitation of facts were what was believed by the jury, then it would sound like that was a violent crime. But we know that the jury did not buy everything that CH had said, or else we would have had a different resolution to the charges. Furthermore, a big difference between Proctor that makes it more egregious. Unlike Mr. Riffey, the district court recognized that Mr. Proctor had impulse control problems. And what we can glean from the case here is that the district court found that this was a one-time type situation. There's a big difference from public safety, from someone that has impulse control problems to a single situation. But nevertheless, we think that yes, the district court did properly make those findings. And again, we think the Court of Appeals was reweighing those facts. We don't know what the district court thought with respect to the severity of the offense. The Court of Appeals just speculated that, well, it must have thought this. And I've already said why that's a problem. Unless the court has, that's the conclusion, presentation.
My question is, what are you asking us to do?
We would ask the court to affirm the sentence as it is. Just Mr. Riffey did not originally appeal this, and he was okay with the 10-month term of post-release supervision.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning and this afternoon. The court will take this matter under advisement